Let's revise the first 3 chapters of court procedure. This is not even going to take 15 minutes. Let's jump straight into it. Action, and we have applications, right? And with an action, we're exchanging pleadings, and with applications, we're exchanging affidavits, right? So, what's the point of a pleading? Like, what's the reason? Everything that we do, there needs to be a reason behind it. So, the reason why we have pleadings, the function of a pleading, is for it to define the issues in dispute, to inform the other party of the case that they need to make or to meet, and also to define the issues. The court also needs to know what the issues are, so that it also knows how far it can go. What are its powers in terms of, the issues in dispute, right? Next, how do we know what rules to follow when we're drafting pleadings? This is simple. So, just before I touch on it, as we're moving along, what I would do is I would do a mind map, right? You'll see with the next section, I would do a mind map where I'm writing the rules, the applicable rules, because in that way you see the whole picture come together. So when we're dealing with pleadings, we are hereby regulated by High Court Rule 18, subsection 3 and subsection 4, right? Some people will say it's the Uniform Rules of Court, or some people will say High Court Rule, used interchangeably. Okay, so we're looking at High Court Rule 18, subsection 3 and subsection 4. High Court Rule 18.3 states, every pleading shall be divided into paragraphs, including subparagraphs, which shall be consecutively numbered and shall, as nearly as possible, each contain a distinctive averment. Right? Subsection 4. Every pleading shall contain a clear and concise statement of the material of facts upon which the pleader relies for his claim, defense, or answer to any pleading, as the case may be, with sufficient particularity to enable the opposite party to reply thereto. Simple. Pare paragraph, put in enough information. So remember, I'm rushing through this because this is revision. I'm not going to cover every aspect, but I'm going to try and cover things that always come up. Okay, so let's talk about action proceedings, right? With action proceedings, we know that in order to start action proceedings, summons need to be issued, right? So now, before we run through the whole thing, let's talk about summons. There are different types of summons. There's a simple summons, there's a combined summons, right? What do we know about a simple summons? Simple summons is a simple document that's straight to the point. Attached to a simple summons is a declaration, right? Remember that. Now, when you have combined summons, what do you have attached to it? A particulars of claim. It's very important to distinguish between the two. With a simple summons, there is a declaration. With a combined summons, there's a what? Particulars of claim. What is the function of a particulars of claim? What is the function of a declaration? They have the same function. Okay, fine. Summons, sharp. Now we move on. So, with summons have to be served by the sheriff on the defendant, right? They have to be served. Sharp. Once the summons are served on the defendant, or the summons is served on the defendant, then the defendant has to serve the plaintiff with a what? With the notice of intention to defend, right? So as you're going through all of this, write down the applicable magistrate's court rule on the left, or the right-hand side actually. Right-hand side in a different color. So as I'm saying summons, you're writing summons, different types of summons. What's the rule regulating that summons in the match court, right? Because you're going through that side. Then, when you're done with that, on the left-hand side, you're going to write the rules that have to do with that from the High Court. Do you understand what I'm saying? So you have one page, you're writing down the process. Summons, notice of intention to defend, all of that. You're writing down which rule is applicable in the match court, in different color. On the other half of the page, the rule that's applicable in the High Court. At the same time, while you're doing that. With another color, 2 other colors, you're writing down the time periods. This must be served within 10 days. This must be delivered within this many days. Because when you look at that one page, you have all your information. Okay, so I'm gonna read the whole process, right, from scratch, because I've been giving little tips in between. I don't want to create confusion, right? Please remember there's a difference between a document, right, or pleading being served and one being delivered. Remember, service basically starts the whole process, and when a document is served, it's served by the sheriff, right? Do you understand? Served by the sheriff. It's important. It's a very small thing, but it's very important. So here we go. We have summons being issued. Once the summons are issued, the sheriff then serves them on the defendant. The defendant then serves the plaintiff with a notice of intention to defend, right? Then the defendant also delivers a plea and a counterclaim, right? At this point, we need to know what a plea and a counterclaim are, and we need to know which rules regulate them. If we don't know, we put it in there, and then we expand on it. We put the rule there and we expand on it. The defendant delivers the plea and counterclaim. Then the plaintiff delivers replications and plea to the counterclaim, right? So normally, at like with board exams, that's normally where they stop. They don't normally go deeper, because it can become a lot. It can get complicated, especially if pleadings are exchanged and it just goes on. So that's where we stop, right? And then we're gonna say that pleadings are closed. You need to know what it's called when pleadings are closed. What do we call the close of pleadings? And I know they do this a lot in law school. There's a whole case. Okay, so since we know the Latin term for close of pleadings when pleadings are closed, right? We need to know the certain characteristics, let's say, of when pleadings are said to be closed. And what are they? When the parties agree in writing to close the pleadings and file the agreement with the registrar, the last day of filing of replication or subsequent pleading has passed without filing, either party joins issue without adding any new matter or pleading, when the court orders the pleadings to be closed after a party applies. Make sure that you just check in your civil procedure book. I'm not sure if there were 4 or 5 characteristics of when pleadings are said to be closed. And please remember to also use the Latin term in this instance. Also, in terms of pleadings, what else do we know about pleadings, right? Specific things that are very important. We know that every pleading must be signed by an attorney, right? Or if a party is unrepresented, he or she must sign those pleadings themselves. We know that the description of the parties and the case number must appear at the top of the pleadings. Pew, pew, pew. We know that. We know that each pleading must be divided into paragraphs with consecutive numbering. According to which rule? On the court. Which court? High court? Which rule? Large court? Which rule? And we know that each pleading must contain a clear statement of material facts. According to which rule? The nice thing about application proceedings is that it's simple. And with an application, you have a notice of motion. Attached to the notice of motion is going to be your founding affidavit. Then moving forward, it's just going to be an exchange of affidavits. You just need to know which affidavits are going to be exchanged, right? So there are different types of affidavits. There's the founding affidavit, which we attach to the notice of motion. There's an answering affidavit, which answers the founding affidavit. Then there's a replying affidavit, right? And then, there's a supporting affidavit. Make sure that you know the difference between those: founding, answering, replying, supporting. Now, I thought that a nice way to wrap this whole thing up is to talk about incidental/interlocutory applications, right? This is an application that is secondary to the main claim. So it's incidental. So it happens by mistake. Do you understand? In other words, it's an application pending the main case. Okay? So this is in the High Court. This is now regulated by High Court Rule 6, subsection 11. It just discusses interlocutory applications. A simple example of an interlocutory application. When I was a candidate attorney, we used to repossess cars and houses. So now when you're repossessing a car during the process, right, especially once the person whose car you're possessing, once they know about the fact that this process has now been started, you've served everything on them, what they normally do is they would get rid of the car, they would dispose of the car. So in order to prevent them of disposing of the car, what we would do is we would now institute an interlocutory application, excuse me, I'm very tired, in order to prevent them from selling the car. Because then the court would give us an order, right, in order for them to hand the car in, or in order for us to then maybe take the car and hold the car until now the matter has been heard. I hope that's a simple enough explanation of what an interlocutory application is. Inter, during, inside, in between, inter, inside, in the middle of. Interlocutory application, it's interlocked, so it's incidental, it's secondary, between the main case. Interlocutory.